Hello friends, welcome to Abhinav Goswami Law classes. So friends, in this video we are going to discuss section 39 of Indian Evidence Act. So a very important provision, because why this is so important? This section tells you the way that if a particular statement is forming part of a big document or big conversation, so how much part of that conversation or part of that document can actually be taken, is actually relevant. So it is doing two important things. This section is providing one thing, that a particular statement, a particular relevant statement may form part of a big conversation or a big document. And secondly, it is also providing that how much of it, how much of that big conversation or that big book or that big document, that relevant statement can be taken, how to demarcate that. Okay friends, so let's start with our discussion on section 39, a very important provision. So friends, section 39 reads, what evidence to be given when statement forms part of a conversation, document, electronic record, book, or series of letter or papers. Okay. So what are the categories of things that are included within the definition? Conversation, document, electronic record, book, or series of letters or papers. So these five categories of works have been specifically mentioned. When any statement of which evidence is given forms part of a longer statement or of a conversation or part of an isolated document, or is contained in a document which forms part of a book, or is contained in part of electronic record, or of a connected series of letters or papers. Now important part starts. Evidence shall be given of so much and no more of the statement, conversation, document, electronic record, book, or series of letters or paper as the court considers necessary in that particular case, to the full understanding of nature and effect of that statement and of the circumstances under which it was made. So both things, nature and effect, as well as the circumstances. So friends, what section 39 is actually talking about is that, suppose if a particular statement is forming part of a book or a big document or a series of lectures, series of letters that were exchanged, or a part of conversation. So friends, the question arises that statements is not an independent statement, it is forming part of something, a transaction. So we can take the evidence of that statement, that is fine, but the question is how to take it out. For example, this is a book in which a lot of sections are mentioned, but for you only a particular section is relevant or a particular line is relevant. How will you take out that line, and what are the rules regarding that? That is section 39 talking about. Section 39 firstly says that any statement that is mentioned in this conversation, document, electronic record, book, or series of letters and papers, it can be taken out. But how much of it can be taken out more has been told by the second part. The second part says that who is going to decide that how much of the statement should be taken out? It is the court, and court is not free to act on his own discretion. Court must consider it necessary. The statements it is taking out, one line, two line, three line, four line, 2 pages, 3 pages, how much soever the court is taking out, the court must consider it necessary. Necessary for what? Necessary for understanding three things: necessary for understanding the nature of the statement, necessary for understanding the effect of the statement, and finally, and most important, also things that were necessary to understand the circumstances in which that statement was made. So not only that statement, but the other facts which are indicating the circumstances in which that statement was made can also be taken by the court of law. Okay. So this is very important point to understand, that the court must consider it necessary, that the howsoever big part a particular court is relying on as relevant fact, it must consider is necessary for understanding the nature, effect, and circumstances of that statement. Okay friends, so this is what section 39 was. It was quite easy, but yet in practical circumstances section 39 becomes quite important. Okay, so for example, there are series of conversation that is happening between two parties. Now there is a dispute among them, so they must be talking about everything, right? About their business, about their personal life, which may not be related to the case, but may work on the mind of the judges. Okay, that such person is a such he's not having a good conduct and whatever. So we can't rely on that. We can only take such a statement which is hinging upon nature, extent, and circumstances of that statement, which is relevant for the case, not other things. So this is a protection against biasness that may arise in the court of law if we take the entire document, entire conversation into consideration. Okay, friends. So this was our discussion on Section 39 of Indian Evidence Act. I hope you understood what I was trying to say. So friends, if you want to appreciate my efforts, please subscribe to my YouTube channel. The link to, and if you want to be part of my Telegram group, the link to my Telegram group is in description to the video. Click on it and be a part of our group. Until then, friends, be safe, be happy. I'll see you very soon. Bye bye.